Okay, I see Lynn's giving the thumbs up. Great. We're going to go on the record now. Good morning, everyone. We are opening the record in the appeal of the Regents of the University of California before the Office of Tax Appeals. The case number is 190-64889. It is currently 10 a.m. on August 19th, 2020. Consistent with the governor's executive order number 25-20 to reduce and minimize the spread and risk of coronavirus infection, and with the agreement of the parties, this hearing is being conducted via Webex video conferencing. Today's case is being heard and decided equally by a panel of 3 judges. My name, once again, is Win Dang, and I will be the lead judge for purposes of conducting this hearing. Also on the panel with me today are Judges Andrew Wong and Joshua Aldrich. At this time, will the parties please state their appearances, beginning with appellant?
This is Jacob Bolot representing the appellant.
Thank you. And CDTFA?
Chad Backus with the department.
And Scott Claremont with the department.
And Jason Parker with the department also.
Thank you. As previously discussed at the pre-hearing conference, the sole issue presented in this case is whether Cardiogen 82 is an exempt medicine. Mr. Bolot, is that correct?
That is correct.
Thank you. And CDTFA, is that correct?
Yes, that is correct.
Thank you. Prior to the hearing today, the parties were provided with a copy of the exhibit hearing binder for this appeal. The binder contains appellant's exhibits 1 through 6 and respondents' exhibits A through G as we have received them. Mr. Bolot, did you have a chance to review that hearing binder? Does it appear correct to you?
Yes, it does. Thank you.
And do you have any objections to the admission of this hearing binder into evidence?
No, I do not.
Thank you. And CDTFA, I'm going to ask you the same questions. Did you receive the binder? Any issues with it?
Chad Backus with CDTFA. Yes, we received the hearing binder and we do not object to any of the exhibits.
Great, thank you. The hearing binder containing the parties' exhibits for this appeal is now admitted into evidence. Hey, Mr. Bolot, if you're ready to begin with your present 15 minutes.
Thank you. Again, my name is Jacob Bolot. I am representing the appellant. Thank you for the time and opportunity for us to present our case before the Office of Tax Appeals. As you stated earlier, the department's decision to ignore FDA drug classification and the incorrect application of historical rulings remains our single disagreed issue with the appeals decision dated May 2nd, 2018. This disagreement stems from the purchase of a drug product made by UCSF Medical Center from Braco Diagnostics. The drug is marketed under the name Cardiogen 82. I will refer to it as RB82, which is the actual drug name for this presentation. This drug meets the requirements of an exempt medicine as a preparation substance when carefully examined under Section 6369 and Regulation 1591. Our submissions and exhibits provide the panel with a logical basis of how this product falls squarely within the definition of an exempt medicine and why the department misses the mark on trying to rely on rulings that are completely unrelated to how RB82 is used, sold, and injected into the patient. First, I would like you to refer to Exhibits A and B, specifically pages 104 to 107 in the package, which provides FDA-approved published information about the drug and support the following undisputed facts. The FDA recognizes Cardiogen as an approved injectable radioactive drug with an active ingredient of rubidium RB82 chloride manufactured by the exact retailer for the questioned transaction. The drug is sold with the following components: medication, which is absorbed on a stannic oxide strip used to hold the drug for delivery, a protective container that encloses the drug and used for storage and handling of the medication, and then internal components to allow saline in and out of the container and to elute or absorb by means of a solvent, which is a key term, medication from the container via saline solution. The saline solution, along with the RB82 drug, injects into the patient. The drug has a dosage life maximum of either 17 liters of saline passing through it, or 42 days from initial use, or when it reaches a minimum level, whichever occurs first. After that, the medicine is no longer useful and must be disposed of, all within a maximum of 42 days. There is no mechanical, chemical, or other physical process within the container, nor is there any means of making a new product. It's simply absorbed by the saline as it passes through the drug container just before injection into the patient. The department in their decision cites and relies on two different annotations, annotation 425.0771 and 425.0765, in determining their tax treatment. Annotation 425.0771 from 1994 relies on annotation 425.765, which was from 1977. 425.0771 doesn't provide any real base or logic around the decision other than referring to the 1977 decision. Both of these decisions predate the revision of Regulation 1591, where Section A9A was added to rely on FDA classification first. They are the medical experts and provide guidance to the industry, which is why Regulation 1591 was updated to help taxpayers and the department. Now let's look carefully at the logic behind annotation 425.0765 and why it should not be used here. This ruling equates the question products, which have a half-life of several decades, to X-rays and sunlight. These items physically generate a new substance, X-rays, ultraviolet light. These items do not contain the final medicine injected into the patient. There is a conversion process. These items have a useful life of many, many years or decades. Thus, those question products in that ruling physically generate a new substance over an extended period of time and are reusable, and they should remain taxable. RB82, on the other hand, is the final radioactive drug with a finite amount of medication in the delivery container. There is no physical, mechanical, chemical, or any other process of producing a new substance within the container. Rather, the RB82 drug is stored and then eluted or absorbed by the saline, which is then injected into the patient. This process was established by the manufacturer for a safe storage, transfer, and delivery of a dangerous radioactive drug when exposed to the public. This process is completely different from the annotation cited by the department. This panel should rely on the FDA classification. They are the experts, not the department. Now I would like to refer to Exhibit C, page 119. This illustrates how both the RB82 drug and other accepted intravenous drugs are delivered to patients. The first illustration on the top shows how RB82 product is delivered. The only item in question is within the red square. All the other items are purchased separately. The actual medication is within the yellow rectangle inside that red square on the top of the page. The saline simply goes in, elutes or absorbs the medication, and then is injected directly into the patient. Again, there are no other changes, events, or other steps in this process. The second illustration on the bottom shows how the normal exempt intravenous drug is delivered through a meter. Primary A would normally be the saline, and secondary B would normally be the exempt drug. Again, that is also in the red box. The saline in this bottom illustration is also mixed with the drug for safe metered delivery. While the mechanics are slightly different due to the handling of the drug RB82, the illustration shows no substantial difference. Both drugs are stored in a container or a bag, have a connection to the IV line, and are mixed into the saline diluted for safe delivery, and then injected into the patient. The department has never tried to argue that the bag of medicine is taxable. There is 100% certainty that those items qualify as exempt medicine. RB82 is exactly like a regular bag of medicine. However, due to the dangerous nature of the radioactive drug, the handling and delivery have to be modified for safety. This slight difference does not make this product different or taxable. Instead, it is a slight modification to an exempt bag of medicine. Finally, we have provided Exhibits D and E to provide rulings, definitions, and other relevant information as you work through your analysis. This area remains complex for audit. I humbly request that the panel redirect the department to rely on expert FDA information rather than trying to go it alone. I would like to conclude and ask the panel to take a fresh look at this case. Historically, the board served as a great avenue for taxpayers to present alternative perspectives. I hope that the OTA will continue this tradition. I also ask for consideration for precedential treatment so that the department is guided to look to the FDA first and not try to ignore it without any basis. This concludes my opening statement. I will try to answer any questions to the best of my ability. Thank you.
Thank you, Mr. Bullitt. At this time, I'd like to ask my co-panelists if they have any questions for you, beginning with Judge Aldrich.
I don't have any questions at this time. Thank you.
Judge Wong, do you have any questions?
Well, I do have a few questions, Mr. Bullock. The first question is, what is strontium SR82?
Sorry, pardon me, can you repeat that question? I couldn't hear you. I forgot I had it on mute.
Sure. This is Judge Wong. My question is, what is strontium SR82?
Strontium SRT. So when the manufacturer makes the product, they have a process where they create the medicine and then they store it on that strip of oxide within the container. So when they give it a scientific name, they've got the name of the SR82, which is ultimately the RB82. So what happens is as the drug passes through it picks up the drug and as it's injected.
This is Judge Wong. So is strontium 82 the same? You said, is it the same as rubidium chloride, RB82? You said it's ultimately. What's the difference, or are they the same?
So the strontium is actually placed in the container. It is the same drug. It's just a more stable format of that drug. So it'll last longer within the container. Once the saline goes in and picks it up, what happens is it picks up a very small amount, which is the RB82, because it obviously can't deliver a huge amount of radiation to the patient. So as it picks up the RB82 or the RB82, that's the drug that's actually injected into the patient. So it's actually just running through a filter or through the system where it's absorbing it, and it's absorbing it through within the container, because the SR82 is what holds the RB82.
So SR82 holds the RB82.
Correct.
This is Judge Wong again. So when the Cardiogen 82 is delivered to your client, it contains the strontium 82 or the rubidium chloride, or both?
The RB82 and the SR82 are one and the same. It's just a different format. It's like basically when you buy a drug, and when a pharmaceutical company may buy a drug, they'll buy a large volume of it, or they'll buy a bigger component of it, and then they'll want to then titrate it and bring it down to a deliverable amment where they can deliver it to the patient. So the SR82 is the bulk amount, and the RB82 is the titrated metered down amount of what is delivered to the patient.
This is Judge Wong. Could you explain what titration means?
So titration is basically a process where the medical professional is going to determine how much medication, what dosage level they're going to deliver to the patient. So they receive it they buy it at a certain volume of potency, and when they deliver it, they obviously don't want to deliver the potent medication because it would do more damage than good. So what they have to do is they mix it with the saline to get it down to a portion that's deliverable to the patient. If you look at the illustration that we gave you on section B, the same thing happens with the drug. The drug is mixed in with the saline, and then it is basically metered down to a safe deliverable amount. If too much is given, then what happens is it actually could damage the veins and process of delivering medication because it would expose the body to more chemical than it can take.
Okay, thank you. I just have one more question about your exhibit E. That is it seems to contain a container theory of non-taxability. Could you elaborate on that?
Can you repeat that? I didn't quite understand.
Sorry, it looks like 1589, or sorry, it looks like exhibit E involves like some sort of container theory of taxability relating to regulation 1589. Could you elaborate on that theory a little?
So there was, and I included in the package of the exhibits, there is a ruling basically that says a container takes the characteristics of the product within what is sold. So if I have a exempt medicine that's included in a container, and I have a bag, and I have tubes, and I have connection devices to it in order to deliver the medication, those other non-medication container items don't change the taxability of the product. What happens is the product inside is exempt, therefore the container takes the characteristics of the product and remains exempt. And that actually, the ruling that I provided actually goes even further, that says even if an item is preloaded and implanted or injected into the patient, even if it's an instrument, those items are exempt. And that has been historically proven with various products, from staplers to stents being implanted to a lot of different products. I think the department has always allowed those types of things, has ignored the container as a non-issue when determining the tax treatment.
I have no further questions at this time.
This is Judge Dang speaking. Just a few brief questions for you, Mr. Bullitt. I was listening to your explanation to Judge Wong's question regarding the relationship between strontium SR82 and rubidium, I'm sorry, RB82. And I'm wondering, as I was looking through Exhibit B, which I believe was the product data information sheet, I wasn't able to find any support for that explanation that you had given Judge Wong. I'm wondering if there's anything, any language in that data sheet you could point to that might explain the relationship between SR82 and RB82?
So I'm looking, I mean, there's a long, trying to find
This is Judge Ding again. I just don't have a technical expertise in this area, and at least upon my reading, it appears that SR82 might be some type of reagent, more similar to reagent than the actual, drug that's injected into the patient. And I believe, as you mentioned earlier, that, I'm sorry, let me finish my sentence. And I believe the reason for that is because of the highly, as you mentioned earlier, the highly radioactive nature of SR82 as compared to CB82.
This is Jacob. That is correct. What happens is that you may know, and we're not experts here, but radiation has what's called a half-life. And so what a half-life is basically is the amount of time that it stays in the current format that it's in. So when radiation is delivered to a patient, they want to have it as titrated down as possible. And they want it to be in the body for as minimal amount of time as possible for the safety of the patient. So when they manufacture the product, they have to manufacture the medicine to the point where it can be packaged, delivered to the medical facility, stored for the medical facility, ready for usage, and then be able to inject into the patient. So the SR82 is a longer term version of the same medicine, of the RB82. So the SR82 has a half-life of, I think, a couple of weeks or something like that, or maybe a few months. The RB82, when it's titrated out, has a half-life of a few minutes. Basically what happens is that because it's titrated down so much, it doesn't have a longer life. Now, I would have to go through and I mean, it's a very complex analysis the FDA puts together. I'm sure I could go through and find and provide sites and information to provide that information to you. But I would have to probably do it after the fact.
This is Judge Dang speaking. I guess my confusion when I'm looking at this data sheet is I'm unable to see whether or not this is more similar to, say, diluting the product down, in which case it's the same product, just in a more diluted form, versus you've now changed the chemical substance that's being injected into the patient. Is there anything, you could take a minute if you like, is there anything in this data sheet or any of the other exhibits that you submitted that might indicate it's the former rather than the latter?
So if you go to page 109, when you go to the testing process, it says on the middle of the page, it says when they're going through and they're evaluating, they're testing the material before them. So they have to, the person who's doing the delivery has to evaluate the level of medicine in the product, and also has to make sure that the product is safe for use for the patient and has enough medication. So they go through a testing process, and it goes through the formula of how the conversion happens, or how the dilution and titration happens. And it provides information of how the relationship of the SR82 and the RB82 is. There's a lot of information in here on that conversion. I'm not sure that it answers the exact question of what you're looking for. If you go down to page 110, it gives you the mathematical formula of the conversion, of what the limits are. It also, on page 110, provides you the physical decay chart of how long the product decays from RB82 to SR82, and how long RB82 is usable out in the open. In the container, it has a longer life because it's stored, it's sealed, it's in a leaded container. Once it's outside of that container, now all of the elements within the air and everything else increases that dissipation or radioactive process. I'm not sure that answers your question, but there is a lot of information in this FDA published information. If you go back to, and I would go back to Exhibit A, when you look at the actual FDA product of how it's set up, they're looking at when they define what they have it. First of all, they have it classified in the Orange Book, which is where they keep all of their drugs. They have it classified as the active ingredient of rubidium RB82. They have the product name as Cardiogen 82. That's the name of the prescription. Again, it is defined by the FDA as an injectable injection, not defined by the FDA as a piece of equipment or some type of reagent, as you said, or anything like that. It is defined specifically as an injectable injection, as a drug within the Orange Book, which is where they classify their drugs.
Thank you. This is Judge Dang. again. And that leads me to my final question for you, Mr. Bullitt. Were you able to find any anything in the rulemaking file or any legal authority perhaps that suggests that we should be applying the FDA definition of drug here rather than, I guess, the plain and ordinary meaning of the word drug?
Well, I think the primary place you're going to look at is 1591A9A, where it tells you that the FDA should be used for identifying what a exempt medicine is. And that language was added much later to these rulings, more recently actually, and probably within the last, I think, few years. And that language was added because the department consistently wanted to ignore the FDA. And there were the actual issue in that particular revision was related to cosmetic implants. And what happened was a lot of times cosmetic implants are used for reconstructive surgery. And the department was always saying, no, those items are not exempt because it's cosmetic, it's not, there's no medical purpose. And the revision was added to say, no, department, you can't make that decision. That decision should be made by the FDA. And in that scenario and in that situation, the department was instructed to look at the FDA first. So that's probably the strongest area that I would rely on.
This is Judge Dang. Thank you for your responses. Co-panelists, did you have any questions before we turn this over to CDTFA? Judge Aldrich?
Not at this time, thanks.
Thank you. Judge Wong?
This is Judge Wong. I had no questions at this time.
Okay, thank you. And CDTFA, if you're ready to begin, you'll have 15 minutes for your presentation.
Thank you. This is Chad Backus with the department. Today's hearing involves two separate and distinct items. The first is Cardiogen 82, which is a medical device that generates rubidium RB82 chloride. And the second is rubidium RB82 chloride, which is a chemical compound that is injected into the human body. Throughout my presentation, I will refer to the first as Cardiogen 82 and the second as rubidium chloride. According to the prescribing information sheet found in Exhibit D, Cardiogen 82 is a closed system used to produce rubidium chloride for intravenous use. Exhibit D also explains that rubidium chloride is a radioactive diagnostic agent indicated for positron emission tomography imaging. The information sheet also states that the Cardiogen 82 should only be used with a specific infusion system designed for use with Cardiogen 82 and capable of accurate measurement and delivery of doses of rubidium chloride. The Cardiogen 82 safety data sheet found in Exhibit E, I should say the department's Exhibit E, states that Cardiogen 82 contains strontium SR82 and SR85, which are absorbed on a hydrous stannic oxide column, which is encased in a lead shield and surrounded by a plastic container. Strontium SR82 has a half-life of 25 days, and strontium SR85 has a half-life of 65 days. When sterile, pyrogen-free sodium chloride injection is used to elute the Cardiogen 82, the diagnostic agent rubidium chloride is created. The rubidium chloride decays with a physical half-life of 75 seconds. Once the rubidium chloride is produced, it is injected into the patient to evaluate myocardial perfusion, which is to say it helps detect coronary failure. Revenue and Taxation Code Section 6369, which is interpreted and implemented by Regulation 1591, exempts from sales and use tax the gross receipts from the sale of and the storage, use, or consumption of medicines. Regulation 1591 subdivision A9 capital A states that medicines means any product fully implanted or injected in the human body or any drug when such is approved by the United States Food and Drug Administration to diagnose, cure, mitigate, treat, or prevent any disease, illness, or medical condition regardless of ultimate use. Subdivision A9 capital B states that medicines also include any substance or preparation intended for use by external or internal application to the human body in the diagnosis, cure, mitigation, treatment, or prevention of disease, and which is commonly recognized as a substance or preparation intended for that use. Regulation 1591 subdivision C2 states that the term medicines does not include articles that are in the nature of instruments, apparatus, contrivances, appliances, devices, or other mechanical or physical equipment, or article or the component parts and accessories thereof. Regulation 1591 subdivision B gives some exceptions to this general rule for devices that do meet the definition of medicines, including permanently implanted devices, prosthetic devices, orthotic devices, and programmable drug infusion devices. Initially, we want to acknowledge that we are not scientists and we are not doctors. So we must rely on the information provided by the manufacturers of these products to help us determine whether an item qualifies as a medicine under the sales and use tax law. Based on the information provided by the manufacturer here, which is Bracco, and can be found in Department's Exhibits D and E, an external saline solution, meaning a solution that is not contained within the Cardiogen 82, is introduced into the Cardiogen 82 and reacts with the radioactive material housed inside the Cardiogen 82, which, as we've heard, is the strontium SR82 and SR85. Now, this creates a new chemical compound of rubidium chloride. It is the rubidium chloride that is injected into the human body for the purpose of diagnosis. There's no dispute that the rubidium chloride itself qualifies as a medicine because it is a substance that is fully injected into the human body for the purpose of diagnosing a medical condition. However, it is not the sale or use of rubidium chloride that is at issue in this appeal. Rather, it is the sale of the Cardiogen 82. As for the Cardiogen 82, we note that the manufacturer information states only that the Cardiogen 82 is a generator of rubidium chloride. The Cardiogen 82 houses one component of the compound needed to create the exempt rubidium chloride. Therefore, it is a necessary part of the process of producing the exempt medicine, but by itself does not meet the definition of a medicine. The Cardiogen 82 is not fully implanted or injected into the human body and is not a substance or preparation intended for external or internal application to the human body. The Cardiogen 82 is a medical device that is not permanently implanted and is not a prosthetic, orthotic, or a programmable infusion device. Therefore, the Cardiogen 82 is excluded from the definition of medicines under Regulation 1591, Subdivision C2. Regulation 1591, Subdivision A9, capital A, does state that medicines include any drug or biologic when such is approved by the United States Food and Drug Administration to diagnose, cure, mitigate, treat, or prevent any disease, illness, or medical condition. We acknowledge that the Food and Drug Administration has approved a drug named Cardiogen 82. However, based on information found on the FDA website, the active ingredient of the FDA-approved drug, Cardiogen 82, is listed as rubidium chloride RB82. And the dosage form or route is listed as an injectable. While the name of the FDA-approved drug is listed as Cardiogen 82, based on the information available, it is our understanding that the FDA actually approved rubidium chloride, which is consistent with the department's position. The actual Cardiogen 82 is not a drug or biologic. It is a device, and it cannot be injected into the human body. This result is consistent with how the department has historically treated radionuclide generators like the Cardiogen 82. For example, annotation 425.0771 dealt with a similar radionuclide generator that is at issue here, based on information provided to the legal department at that time that the backup letter to the annotation was written. That taxpayer stated that the generators are constructed on the principle of growth relationship between a long-lived parent radionuclide and its short-lived daughter radionuclide. The parent is attached to an exchange column, which decays to a short-lived daughter radionuclide. The daughter then can be chemically separated from the parent by a solvent that is pulled through the generator. In that case, the parent was molybdenum 99, and the daughter was technetium 99M. In this case, the parent radionuclide would be the strontium SR82 or 85, which decays to the daughter RB82, rubidium 82. The process, going back to the backup letter to the annotation, the process produces technetium 99 pertechnetate, a radiopharmaceutical injected into a patient as agents in brain, thyroid, salivary gland, and other imaging processes. The result from that letter is annotation 425.0771, which states that while the products of a generator may be classified as medicines under proper conditions, the generators themselves are nothing more than a piece of equipment and are not within the definition of medicine for sales and use tax purposes. The similarities with that backup letter and with the Cardiogen 82, they're basically, the processes are exactly the same. The generator is shipped with the strontium SR82 attached to the column, and that decays to RB82, rubidium RB82, which when that is eluted with the saline solution produces rubidium chloride. Chloride being the definition of the solvent that comes through and attaches itself to the daughter radionuclide. And then as for appellant's contention that the Cardiogen 82 qualifies as an exempt container, we heard about that right at the end. In appellant's exhibit E, he attached a letter from the legal department. We note that that regulation 1589 subdivision B1 capital D exempts from tax containers sold or leased with the contents if the sales price of the contents is not required to be included in the measure of the sales tax or the use tax. To be considered an exempt container, the contents of the Cardiogen 82 would have to be exempt from tax. However, as previously stated, the contents of the Cardiogen 82 include strontium SR82 and strontium SR85, neither of which are exempt from tax. While rubidium chloride is exempt from tax, that chemical compound does not exist until an external saline solution is introduced into the Cardiogen 82. Therefore, the Cardiogen 82 is not sold or leased with contents that are exempt from tax and cannot be characterized as an exempt container. Based on the foregoing, Cardiogen 82 is a medical device that through an elution process generates the exempt medicine rubidium chloride. Cardiogen 82 is not an exempt medicine and does not contain or house an exempt medicine. And I think Scott is going to give some more background on Regulation 1591A9 capital A.
Yeah, thank you. This is Scott Claremont. I'm just going to comment. Can everyone hear me? I just want to make sure before I keep on. Okay. Just comment on a few of the responses that appellant has made. Firstly, as Mr. Backus pointed out, this is our understanding based on the similarity with the sanitation 0771 and the information that's been provided is that strontium is a radionucleotide that is a different element than rubidium 82, which is a different. To Judge Dang's question, it is a different substance than rubidium chloride. So we disagree with the characterization of the appellant that this is the same as, I think you used the word titrating or diluting a medicine for injection into a body. There is a different chemical compound that's attached. It decays into a different chemical compound. And then when it is eluted, which is a specific type of chemical reaction, it creates a third chemical compound, which is what is produced in the body. And so we disagree with the characterization that this is the same as any sort of IV medication. We also note, again, Mr. Backus noted the similarity between essentially the exact same process, which is described in that annotation, which is our longstanding position, and the fact that there's always been IV medication at the time, like throughout the time that annotation's been in effect. So it has always been our position that this is not, that because of this specific chemical processes that are taking place with this type of generator, it's not the same thing as your standard IV medication. To speak to Regulation 1591A9A, appellant is correct that it was specifically focused on cosmetic surgery, specifically breast implants and Botox. The issue there wasn't a disagreement over whether those things can constitute a medicine or not. The issue there was no disagreement that those did constitute medicines, word medicines, when used for certain purposes. When used post-mastectomy, a breast implant is a medicine. For certain uses, Botox is a medicine. For other uses, they are not a medicine. For other uses, when they're used cosmetically, they're not. So the issue there was how to deal with a product that could be used as a medicine, but also as not a medicine. And you can see from the structure of that sentence, the key point is one, it says, except when, it starts with, except where taxable for all uses as provided in subdivision C. So first it's saying, if something is never a medicine, we're not going to deal with this. And the most important point is the last part of the sentence, which says that it states that it is a medicine regardless of ultimate use. So the main thing that A9A did in Regulation 1591 was it said that if you have something that is a medicine for some uses, we are going to consider it a medicine regardless of ultimate use. So it was not designed to settle disputes over what is or is not a medicine. Yes, it contains, in coming up with that rule, it contains statements about what's covered, and medicines that are approved by the USDA or FDA are some of the things that are covered in that rule. But it wasn't intended to change the analysis of what constitutes a medicine under our regulations. And it certainly wouldn't change the analysis here where you have something that is not a medicine either as a substance or as a excluded device. So we do not think that the implementation of subdivision A9A of Regulation 1591 changes the analysis of the annotation, which yes, it did precede it, but that's been the longstanding analysis, and we don't think Regulation 1591A9A had any effect on that analysis. Thank you.
Thank you. This is Judge Ding speaking. Let me turn to my co-panelists at this time to see if they have any questions. Judge Aldrich, do you have any questions for CDTFA?
Hi, this is Judge Rich. Could you give me an example of what might be exempt under 1591 B6? Is that something like for example, a diabetic insulin device? Would that be something that's worn in infusing medicine?
I think I can. Yeah, that's a specific example. Like an insulin, the type of insulin device that's worn on the body would be considered exempt medicine under B6. As you can see from that definition, it does have to be something that's worn on or in the body. And yeah, an insulin injection device is an example.
Okay, and so, I mean, the crux of the dispute here seems like, and I'll give both of you the opportunity to correct me if I'm wrong, is that the department is drawing a distinction between whatever comes out of the product, right, and is ultimately injected versus the piece of equipment or device or medicine, however we determine that the saline solution is being passed through, right? Whereas the appellant is saying, no, the medicine is one and the same. This device or medicine, depending on how you analyze it, is what should be tax exempt. Is that correct?
Right. The department's understanding of appellant's argument is that the radioactive, the radionuclide, which is contained within the generator, is the medicine, and it's just the saline solution that elutes the radionuclide is just a way to get that medicine into the human body. And he uses the example of the IV, and as we have pointed out in our presentation, and Mr. Claremont in his explanation is that the department sees those things as completely separate chemical compounds or chemical reactions, that the strontium SR82, which decays to the rubidium RB82, those are not medicines. The medicine is only created once the saline solution passes through and harvests the RB82 and creates a third chemical compound, a third solution of the rubidium chloride. And it's the rubidium chloride which is injected and which is the medicine, because it is injected into the human body to diagnose a medical condition.
So the rubidium chloride, if I were able to dry that out into a powder, put it into some sort of a vial, and that is then like reconstituted later in the exact same chemical format, that might be a medicine. But in this instance, because it's changing its chemical structure through these processes, it's not.
Again, it's hard for us to deal in hypothetical situations and to try to figure out what would and would not be, because there are various facts to consider. But in this case, with these facts, because the rubidium chloride, which is the final product, is not contained within the generator, it is a process. It's something that is created after the fact, after the saline solution has eluted the radionuclide. That is the process, and it's not created until after the fact, and it's different having a medication in an IV bag that is diluted with saline solution and then injected into the human body. We believe it is a completely separate and distinct.
Mr. Backus, I'm sorry to interrupt you. Mr. Claremont, would you mind muting your mic, please? We're getting quite a bit of feedback.
Sorry.
Thank you. I apologize, Mr. Backus. Please continue.
That's okay. And so just to repeat the very end, we think it's the IV, the dilution of a medicine for IV purposes is a different process than what is taking place with the Cardiogen 82, where the saline solution is eluting or harvesting a radionuclide and creating a new chemical compound which can then be injected into the human body.
I don't have any further questions, so I'm going to turn it back over to Judge Dane.
This is Judge Dang. Judge Wong, did you have any questions for CDTFA?
This is Judge Wong. I had a couple questions. The first one, just for the record, to clarify the record and make it clear, what does elute mean? Process of elution or the activity of elution?
Right. So elution, if you look on, I think it's included in some of the appellants, in one of the appellants exhibits, also in the manufacturing process. It's a process whereby a saline solution removes the saline solution removes an item, in this case a radionuclide, removes a piece of it to create, and it creates an eluate is what it's called, which is a liquid type of it's basically it's essentially mostly saline solution with some of that radioactive material, and allows that material to be safely injected into the human body without causing too much radiation for the body.
This Judge Wong, you had one more question. If you know, is strontium SR82 or SR85 approved by the FDA for anything?
Not to our knowledge.
This is Mr. Claremont. I believe that from reading the materials in this case and in the backup letter to the annotation, I believe the issue is that strontium, it's the useful life of the daughter makes it medically suitable as opposed to the longer life of the parent. So you wouldn't inject something that lasts that long into the body, whereas the daughter, since it decays faster, is medically useful. I think in some of the materials that have been provided in the safety materials, it does indicate that there will be some strontium that is in the solution, like trace amounts, and that's the danger, is when I believe in terms of balancing the elution reaction, is making sure that you don't get excess strontium. One of the dangers, at least from the materials, appears to be that you don't get excess strontium in that rubidium chloride solution. But I believe that the answer is that it's the short life of the daughter is what makes it medically useful, as opposed to the long life of the parent.
Got it. Thank you. And just to clarify, the position is that saline solution is pumped into the CardioGen 80 generator. A chemical process takes place and out comes rubidium RG82 chloride injection. Is that correct?
Correct.
Thank you. No further questions.
This is Judge Dang. I believe to follow up on Judge Aldrich's earlier question, I believe a second component of appellant's argument was that if the FDA approved CardioGen 82 as a drug, that it should be exempt from tax. I'd like to get the department's response to that.
Sure. This is Chad Backus with the department. Our response is that the FDA did not approve CardioGen 82, the device, as a drug. It approved rubidium chloride as the drug, but named it CardioGen 82 based on the name from the manufacturer. So again, the FDA lists the active ingredient as rubidium chloride RB82, which is consistent with the department's position that rubidium chloride is an exempt medicine. And the FDA also states that the form or the way to administer the FDA-approved drug is through injection. So the department's position is that there's no way that CardioGen 82, the generator, is an FDA-approved drug as an injectable, because it cannot be injected. The department believes that that the naming, the FDA naming the drug Cardiogen 82 is causing unnecessary confusion. That we should actually be looking at what it actually is that's being approved, which is the rubidium chloride RB82 as specified in the FDA materials.
Thank you. Let's assume for the moment that the FDA did approve this product, the generator Cardiogen 82, as a drug, or that the product meets the definition in the Food and Drug Cosmetic Act as a drug. What would the department's position be there? Would it still be taxable, or would it be exempt in that case?
Again, it's difficult for the department to engage in hypothetical questions just because we deal with facts that are in front of us. It's, again, as Mr. Claremont pointed out with when 1591 A9A came about, it didn't change the way we look at what products or items qualify as medicines. It's products that did qualify as medicines for certain circumstances. It then expanded to allow those products to be characterized as medicines no matter what the ultimate use was. So the department would look at whether for sales and use tax purposes under the sales and use tax law, the department would look at whether the item qualified as a medicine in general, and then if it did, then 1591 A9A would then expand that, and no matter what the use was, it would then be allowed. Then we would find that it was a medicine under 1591 A9A.
And this is Mr. Claremont. I would add, sort of in response to that question. I mean, I think this is a unique. As we've said, this is somewhat of a unique situation, and there is a little confusion with how the FDA approval is labeled. But I think generally, if something is a drug and is approved as a drug, and which is a substance or preparation which is approved as a drug, there's not going to be a lot of room between it being a medicine under 1591 B1 drug or preparation, or excuse me, A9B, a drug or preparation, substance preparation that is used to diagnose, and something that's also a medicine under A9A. So, I mean, generally the answer is going to be if it was truly a substance or preparation that was approved by the FDA as a medicine, we would consider it to be a medicine too. But I don't think there's generally going to be a lot of room between those two definitions. There's just the kind of the unique facts of this case where you have what we think is somewhat confusing, somewhat imprecise labeling here, because as Mr. Backus said, the facts are that this product is not rubidium chloride. So the FDA has approved it and has given it the name Cardiogen and said that the active ingredient is rubidium chloride. But the facts are, as all the evidence shows, that when this is sold, it does not contain rubidium chloride, and it does not produce rubidium chloride until the elution solvent is put through it. So we think that in response to your question, we think the answer will generally be that something that's approved as a drug by the FDA will also be a drug under our law. This is a unique situation with these facts.
Thank you, Mr. Claremont. I think my concern was I took a quick peek at the Food, Drug, and Cosmetic Act. It seems as though the definition of what the FDA may consider to be a drug is far more expansive than what we would typically use here with regards to sales and use tax law. If that were the case and CDTFA were to lose on this factual issue, we need to proceed, I think, to the legal question of whether or not the FDA's determination of whether TPP is a drug or not would be controlling in this case. Do you have a response for that? I'm sorry, Mr. Claremont. I'm sorry, you're still muted.
I'm sorry. Can you repeat that question again so I can make sure I heard it correctly?
Yes, this is Judge Dang again. My question was that if CDT, as you've expressed, the labeling is pretty confusing in this case. And my concern is that if CDTFA were to lose on the factual issue here, and we were to find that the FDA approved the entire device as a drug, based on my quick look at the Food Drug Cosmetic Act, it seems like the FDA uses a much broader definition of drug than would typically be applied under the sales and use tax law. And I'm wondering if that were the case, and we were to find that Cardiogen 82 was a FDA-approved drug, the entire device, is the FDA's determination of what's a drug in this case, would that be controlling as to the taxability of this product?
I'm not sure I can, give a broad answer as to how this regulation should be, hypothetical responses, how this regulation should be interpreted. Certainly, 1591A9A does state that a drug approved by the FDA as such, is medicine. So I don't know how broadly that would, as I said, I don't think there is much room between something that is considered a drug or a biologic under the FDA law versus what we would consider to be a substance of preparation that is a medicine. So I don't know how broadly that would affect other items. But our interpretation is that, but certainly the regulation states that a drug that's approved by the FDA is a medicine. I mean, that's what the definition states. Our understanding here is that the drug here is rubidium chloride.
Thank you. This is Judge Dang speaking again. At this time, I'd like to turn it over to Mr. Bullat for your rebuttal. You'll have 5 minutes if you're ready. Please begin.
Yes, thank you. This is Jacob Bullat again. First, I'd like to, before I get into the closing, I wanted to address a few of the issues that the department brought up, if I may. Number one issue that I keep hearing of, and the department has never failed to answer this because they're trying to play the expert and outsmart the FDA. They claim that the device generates, creates, harvests, whatever term they want to use. When you look at the specific language within the FDA approval, and in our Exhibit B, that is the actual label. That's not an imprecise labeling as it was laid out. That is the specific approved FDA labeling of this device. And in this elaborate discussion that they go through, there is only one term that is used, and that is elute. And that is very important because all elution is it means that it is being absorbed by a solvent. There's no chemical reaction as been stated. The department has failed consistently to provide us with any type of an example of what chemical process, what mechanical process, what physical process, what any process that the device that uses to convert one item to another. All that simply is happening is the saline is injected inside the container. It is eluted or absorbed. So basically what happens is the saline goes in, it elutes it, it absorbs it, and then it injects it. The manufactured product SR82 is a longer life product, but it's essentially the same thing. The RB82 is a broken down, shorter life radiochemical that is safe for delivery. Under the department's logic of saying, well, adding saline creates a chemical reaction and therefore makes the drug taxable, then in our illustration exhibit, when the primary, which is the saline, the secondary, which is the medicine, when they meet, they, again, in that situation, they're diluting the drug. Why? Because the drug is the drug in the bag is too dangerous to deliver in the patient. If they injected that drug directly into the patient, that patient's body would react to it negatively and it would do more harm than good. Same scenario here. There's no difference. The only difference is that the container is built so that the product is more stable. A simple bag would not keep the drug stable. It would not keep it safe. It would not be able to. They would not be able to transport it. They would not be able to use it. They would not be able to have as needed basis. If they were to manufacture the RB82 and sell it as this, they'd have to use it in a few minutes. Well, how are they going to get it from point A to point B ready for patient use? The department continues to use the term generate, harvest, create, but it fails to provide any logic or any basis or any facts of what the container does other than absorbing the medicine through saline. The other thing that I want to talk about is 425.0771. That ruling and decision is highly flawed. All it does is it takes a look at the previous ruling from 1977 and says, hey, that 1977 ruling said this product was taxable, therefore we're going to say this product is taxable. It doesn't do anything else. And you can read the background, and I've read it myself. What it fails to realize is that those two products are completely different. In the 1977 ruling, those radioactive materials had half-lives of decades. They were manufactured in a process where they would be around for years. The hospital or the medical professional would be able to use that product for a very long period of time. Here, we have a product that's good for roughly 5 weeks. I'm not talking about years, we're talking about weeks. And that's at a maximum. The reason why they manufacture it that way is because that's the only way they can get it from point A to point B to the patient. So we are trying to equate an instrument, an equipment, a sun lamp, an X-ray machine to a medicine. And that is a flawed regulation or ruling, sorry. And it fails to take anything into consideration when it does that analysis. All it does is say the 77 ruling said this product was taxable, therefore that product's taxable. There's no other analysis done. The next thing I'd like to address, 1591A9A specifically says the FDA is the primary place where we should go and look for answers. We as a department are not experts. I'm not an expert. The FDA is. So, and the language in A9A is very specific. It says that the FDA classifies something as a drug, it should be treated as a drug. Mr. Claremont said that cosmetics are taxable. That is not true. A cosmetic implant is exempt and remains exempt after A9A. The reason why is because the department does not want to have the need to look into patient records. They're not allowed to. So there was a broad application for all implants, whether it was cosmetic or not. They were deemed to be exempt, and there was no further analysis done. Finally, I think that I wanted to talk about this whole concept of a third product. I'm not sure where this came from. The department is saying that the saline mixed with an RB82 is now a third product. That to me makes no logical sense. There's no basis in fact with that. So that's kind of the response that I have. As far as my concluding remarks, again, I want to say the department has narrowed their vision to only look at the rulings that should not be used for this drug. The huge question that they have failed to answer is what proof or fact makes them decide that RB82 is an instrument or cardiogen is an instrument and not a drug? The logic that this panel should use is as follows. The FDA classifies it as a drug. The FDA provides the active ingredient within the drug. They don't provide any distinction. In their Orange Book, they're saying it's a drug. They're saying the proprietary name is cardiogen 82. The active ingredient is rubidium chloride. Their publication and their labeling, which goes through a very significant process of approval, specifically says that it's eluted, which means absorbed. The active ingredient is mixed with the saline after elution and injected. There is no conversion of any type within the container. There's no physical, no chemical, no mixed, or any other process. It simply goes in, absorbs the medicine, leaves the container, goes into the patient. Nothing else happens. The department cited ruling relates to products to a long-term reusable items for decades. I mean, we're talking these products have a half-life of in the 1977 ruling specifically talks about half-lives of 28 and I think it was 35 years. This one, the RB82, has a half-life of 42 days maximum within the container. The department cited ruling analyzes the products that use some type of mechanical, physical, chemical process to create a new substance. We're not creating a new substance. All we're doing is taking a product that's manufactured by the manufacturer, good for 6-7 weeks. We're titrating it down to a deliverable dosage. RB82 is made at the facility, at the manufacturer's facility, packaged into a container, and then it is eluted, titrated, and delivered into the patient via a saline injection. This product is exactly as a bag of exempt medicine. It's modified only for safe handling, delivery, and processing of a dangerous drug. This tunnel vision has led the department to make a mistaken decision back in 1977, and again, they're trying to do it today. This is a very unique product. This is a very unique situation. One of the questions that the panel brought up is, if we were to take the broad FDA definition, would that change it? I don't think we need to go there because the FDA classifies this as a drug. They're classifying the amount of the material inside the container as a drug. The outside of it is all the container, and everything else is all the delivery. In the Exhibit E that we provided a ruling back from 2012, which dealt with the delivery of a stent. And in that stent, there is a delivery system. Catheter, it's preloaded, it's ready to go. All the doctor has to do is take that device, place it into the body, pump up the stent so that it's ready for delivery. Then once it's placed, they remove the device and they toss the device. Well, that device is not taxable because the stent is exempt implanted. That device is deemed to be a container. Even though it does much more than a container, it actually processes the delivery. So I don't think we need to go to the point of saying, well, if the FDA approves it as a drug, we have to look at it as a drug. If the FDA approves the item within the CardioGen container as a drug, then that container, that whole device should be exempt. Thank you for your time and consideration. That's kind of the end of my rant. I apologize.
Thank you, Mr. Bullitt. This is Judge Dang speaking. Before we conclude, I'd like to ask my panel members one last time whether they have any further questions, starting with Judge Aldrich.
No further questions. Thank you.
Thank you. Judge Wong?
This did have one last question for Mr. Bullock. In your Exhibit F, there's like a sheet about the CardioGen 82. You had mentioned that rubidium RB82 is not generated, but it seems to say on the top left, CardioGen 82, and underneath it, it says rubidium RB82 generator. Could you address that? Mr. Bullock, I think you're muted or I can't hear you.
Sorry, I was on mute and I was talking. To answer your question, the product is marketed as a process where they generate, and they use the term generator. And when you look at the actual process of what it does and how it explains it, all it is saying is that it is an absorption process. It's not any type of a generation manufacturing process. There is no internal components that happens. There is no chemical reaction that happens between the saline and the device or the medicine. All it is absorbing it. And if you read through the FDA labeling, The entire process talks about elution. And I fall back to that term because that term, and it's defined in one of our exhibits. It's defined as absorbed by a saline, by a solvent. The solvent here is saline. So there's no chemical process, there's no conversion, there's just simply an absorption. And so that's the process, but the term generator is there. That is, I think, what's causing the department to misinterpret the application of this process.
Thank you. No further questions.
This is Judge Dang. I'd like to thank everyone for their presentations. The record is closed and this matter will be submitted for decision. The panel will meet and deliberate upon the arguments and evidence that have been presented to us, and we will endeavor to send you our written opinion within 100 days from today. I'd like to thank everyone once again. This hearing is now adjourned. I'd also like to note that OTA will be taking a recess until 1 p.m. We'll resume our hearings for the day. Thank you, everyone.
Thank you.